Hi, I'm attorney Casey Walker. I'm the founder of VA Disability Group. The purpose of this discussion is to discuss common veteran VA claims mistakes. So let's jump right into it. Number one, failure to file an intent to file form. VA Form 21-0966 provides veterans the opportunity to submit a form notifying the VA that they're going to submit a claim within 1 year of that form. Ideally, once that claim is submitted, will date back to the intent to file form. Now, what we do on behalf of our clients here is we submit a new intent to file claim once a year because we don't know when a new claim is going to happen. But ideally, we hope that that claim will date back to the intent to file form. Similarly, you should be doing that for yourself. If you think there's a potential that you'll file another claim sometime in the next year, 2 years, 3 years, 5 years, keep filing an intent to file form once a year. And if you ever do, you'll get that benefit, hopefully, of an additional year of benefits or 6 months, depending on when you file the claim. Number two, filing for increases when you're already receiving the maximum benefit. So this one's frustrating. So you see this in two different situations. In the first instance, you'll see a veteran file for an increase when they're receiving what's called the scheduler maximum. So when you go into the VA disability rating schedule, they provide for different incremental benefits of 10, 20, 30, all the way up to 100% in 10% increments. Well, there's times where only a 50%, for example, headaches are capped out at 50%. Tinnitus is capped out at 10%. There's certain things that you reach the maximum. And if you're already receiving the maximum, you don't want to file for an increase because all you're doing is bringing unwanted scrutiny to your file and your claim. And the only way you can go is down. Make sure you're aware as to where you stand with the current evaluation before you file for an increase. Because if you can't get an increase, you're wasting your time and bringing unwanted scrutiny. The other example we see is veterans filing for second and third mental health claims or second and third respiratory claims when the law prohibits more than one compensable evaluation for mental health or respiratory conditions. So for example, if a veteran has PTSD, they also want to file a claim for a major depressive disorder or a generalized anxiety disorder. But if that veteran already has a 70% for PTSD, you're not getting another compensable evaluation for a separate mental health condition. They might service connect it, which is unlikely. They usually lump them together. They'll say PTSD with generalized anxiety disorder. But no matter what happens, the VA will not award a separate compensable mental health evaluation. But what they will do potentially is say, you're right, you do have generalized anxiety disorder, but we don't believe it's service-connected. And then they're going to ask the examiner to delineate the symptoms attributable to generalized anxiety disorder and PTSD. And oftentimes that leads to a reduction. So make sure you know where you stand with your current claims. Don't just file for increases and additional things if you're already receiving a very good compensable evaluation. Another common mistake veterans make is not filing for individual unemployability. Now, this is a loaded topic. We have a separate video. You can find it in the description below. But not filing for individual unemployability when your conditions you're service connected with render you unemployable or render you incapable of maintaining substantially gainful employment. If you fall under that, you should be filing for individual unemployability. You'll do so by filing VA Form 21-8940. There again, you can find a link for this actual form in our description. Another mistake veterans make is skipping or rescheduling C&P examinations. Don't do this. Please don't do this. If you have to drive 2 hours, just make the drive. Sometimes these exams take 2 to 3 months to be scheduled. Sometimes they take 2 to 3 years. These examinations, if they get rescheduled, you're kicking the can down the road by about 6 to 8 months usually. And it can be longer than that. So don't reschedule. And if you fail to go to the exam, it's usually a sweeping denial. So hedge your bet and go to the exam. Drive the 2 hours. If you're willing to drive to go see a concert 5 hours away, drive the 2 hours and go to the C&P exam. If you're not willing to do it, then maybe you shouldn't be filing a claim because you're not willing to do your part to see the claim through. Now, I'm not minimizing this. Some veterans might have conditions that limit their ability to travel far distances. That's not what I'm talking about here. I'm just talking about the veteran who is too much of an inconvenience because they would want to go watch their NFL game that night or something. You have to do your part to make these claims happen. You can't just expect the VA to come up with evidence. So don't skip the C&P exams and don't reschedule them. Number 5, not updating your contact information with the Department of Veteran Affairs or the Veterans Benefits Administration. Email, phone number, address. any of those change, you got to notify the VA. You can send them a written communication to the Evidence Intake Center. A link to their address is found in the description. Or you can call the 1-800-827-1000 number. That's the VA National Hotline number. But regardless, you have to update the VA with your contact information, because what's going to happen is if they need to send you a communication or they need to schedule an exam or a future exam, you're not going to be notified because you failed to update your contact information. And that's on you. So you have to update your contact information. This is basic stuff, but it happens all the time. Update your contact information with the VA. If you're represented by someone, like a representative or an attorney or someone who's helping you with your VA claim, make sure they get the updated contact information too. Don't just do it with the VA. The next step is to notify your representative. Number 6, veterans fail to document their symptoms when a future examination has been scheduled. So let's step back for a second. The VA, on occasion, will schedule future exams. That's a long way of saying that your condition is not static, that it's not permanent, that they think there's a likelihood of improvement. So when you're notified that you're going to have a future examination, it's incumbent on you, the veteran, to establish evidence documenting and demonstrating how severe your symptoms are, so that when the time comes 3 to 5 years later, when the VA is ready to reassess your condition, you've given them a litany of evidence and ample evidence so that they can actually not even schedule the exam. They're going to have it in their hand, in your file. They're going to say, oh, we got symptom logs. Oh, we got a sworn statement, and we have treatments. We have treatment records. So if you can give them all 3 of those, and this takes diligence because it takes 3 to 5 years of perpetual documentation. But if you have a future exam, that's what you have to do. Don't just document it. Don't just be treated for it. Don't just write the sworn statement. Also, please, 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 send it to the VA. Don't just gather it. You have to give it to them too. Don't forget to send it to the VA. You can send it to the VA by sending it to the Evidence Intake Center. Their link is in the description. Another common mistake veterans make is forgetting that there's a clothing allowance available to them. So the VA has a clothing allowance program, and August 1st of every year, an annual application must be submitted to avail yourself to this benefit. There's 2 separate clothing allowances, up to 2 separate clothing allowances that a veteran can apply for. It's a little over $1,000 per clothing allowance. It requires something that your service connected with to degrade your clothing. So for example, if you receive different topical solutions or ointments for a skin condition, and that topical solution might wear down your shirt, you might have to buy more shirts. Or if you wear a mechanical knee brace, that too might be an example where you need to buy more pants because the mechanical knee brace can wear down the pants. Regardless of what your condition is, you should at least be considering whether you're eligible and filing once a year by August 1st of every year. A link to the instructions for that are found in the description. This is number 8. Update your dependents with the VA. So you finally get it. You get your 100% and life is good. I'm done with the VA. And you fail to update your dependents. And 1.5 years later, someone says, well, why didn't you update your dependents? And you say, I didn't know I could do it, or I forgot, or I thought it was automatic. Update your dependents with the VA. It's VA Form 21-686C, and that form is also found in the description. But you have to tell the VA who your children are and who your spouse is. If you have an adult parent, there's a separate form for that as well. An adult dependent parent, that is. But the important thing is you need to notify the VA of your dependents. You have 1 year from a recent VA award to file for the dependency rate. The dependency rates are also found in the description, but the important thing that you need to be aware of is there's a dependency rate, but there's no such thing as a dependency rate that you're going to receive if you don't tell the VA about your dependents. So tell the VA that you have children, tell the VA if you've adopted a kid, tell the VA if you're married. Just make sure you update that with VA Form 21-686C. And when your child turns 18, they will automatically be removed from the dependency rate unless they're in college or in a VA accredited institution. So maybe a tech school or a trade school, as long as it's accredited, the veteran will receive an additional benefit if the child is in a college program or an accredited institutional program. And since we're on the topic of dependents, if you get divorced or a child dies, notify the VA of that as well, because what will happen is a debt will be created. So even in unfortunate circumstances like divorce and death, make sure you update the VA in a timely manner to the extent reasonably possible. Number 9, failing to send evidence to the Evidence Intake Center, or the VA and the BVA. So veterans will put a lot of effort into gathering and developing evidence over the course of 1, 2, or 3 years, but they fail to send it to the VA. If you don't send it to the VA, all of your efforts are in vain. Send the evidence to the VA. Sworn statements, symptom logs, medical treatment records, nexus statements, examination reports, disability benefit questionnaires, whatever it is you're doing to substantiate your claim, you have to give it to the VA, the Evidence Intake Center. So please don't leave that step out. Help yourself and send it to the VA. One other consideration when sending things to the VA and the Board of Veterans Appeals, otherwise known as the BVA, is that if you elect to have a hearing, it might take 3 to 5 years to get that hearing, and you might develop 3 to 5 years of evidence. Keep in mind, under the Appeals Modernization Act, otherwise known as AMA, if you elect to have a board hearing, you have to send all evidence following the appeal decision, which might be 3 to 5 years of evidence, within 90 days after the hearing. So it's something you should be aware of. If you're going to elect to have a hearing, you have to send all of the evidence developed over that period that you're waiting for the hearing after the hearing within 90 days. Don't forget that. If you sent it to the VA or the Board of Veterans Appeals before your hearing, they won't look at it. Essentially what happens is you get your VA decision and you want your day in court, so to speak. So you appeal it to the board and you say, I want a hearing. And let's say that happened in 2020. And then in August of 2024, you finally get your hearing. And let's say you developed great evidence, medical treatment records, sworn statements, symptom logs for those 4 years that you were waiting for the hearing. You have to send all of that evidence to the Board of Veterans Appeals. You can do that through the Evidence Intake Center after the hearing within 90 days. And it's a strict window. So please be aware of that as well. Veterans will just send it when they get it, which is reasonable. But under AMA, they carved out this little rule that you have a 90-day window. You have to send everything to the VA at the same time. And that limits the scope of their review, which makes their job a little bit easier. But that's what you have to do. If you do not elect for a hearing and you do the evidence docket, you have 90 days from the submission of the form to submit additional evidence as well. But regardless, you have to get the evidence to the VA. And when you do, that's dictated by what appeal lane you choose. Number 10, veterans who are incapable of working and receiving individual unemployability fail to apply for Social Security disability. You can double dip. If you're receiving individual unemployability or you're incapable of working because of your service-connected conditions, you should be simultaneously and contemporaneously filing for Social Security disability and VA individual unemployability. If you're already receiving Social Security disability, you need to consider filing for individual unemployability. If you're already receiving individual unemployability, you need to consider filing for Social Security disability. They do not offset each other. This is a great opportunity for veterans who can't work. It kind of levels the playing field because it's quite a burden not being able to work. When your disabilities prevent you from actually entering the workforce, that can be hard financially and mentally. Well, avail yourself to these benefits that you've paid your tax dollars into and file for individual unemployability and file for Social Security disability if you're eligible for such, if your conditions prevent you from working. So there you have it. We just discussed 10 common mistakes. These are mistakes that we see as a law firm all the time. So this isn't something willy-nilly we're throwing at you. We see it. These are real-world examples that happen time and time again, week after week after week, perpetually. If any of these applied to you, I hope you found it helpful to yourself and take action. And thanks for watching. Like and subscribe to the channel. Have a good day.